Good morning. Thank you for attending today's webinar.
Are they joined as someone different because they're saying that all these staff members can hear each other until you start?
Today's topic, the Families First Coronavirus Response Act. Today, I'll be presenting this along with my partner, Dave Herring. We're going to do our best on this relatively new law to educate you and alert you as to what's happening here with this law. The tax portion of this topic is relatively straightforward. I think you're going to see its application to business is very specific in terms of what's happening with the virus in your geographic region and how it's affecting the health and circumstances of your employees. We're going to try and address questions as they come through the email during our presentation. We'll also have time at the end for questions as well. Since we have a big audience today, if we don't get to your questions or you need further clarification on an issue, we've included our information for Dave and I, as well as a couple of our other partners, at the end of the presentation that will be able to help you. One last thing, as with any new tax law, there will be many questions about various sections of that law that really can't be answered until regulations are issued. Currently, with the law being so new, we don't have those regulations yet. We have been in consultation with a couple of partners in large law firms here in Syracuse that specialize in this area, and they concur with us that the regulations are especially necessary with these new laws. So with that, we're going to get started on our presentation. As you'll notice in the very first slide, the picture there, social distancing was not observed. But let's get started. So this law has really two components. One is brand new. It's the Emergency Paid Sick Leave Act. The other is the Emergency Family and Medical Leave Expansion Act. You're familiar with the Family Medical Leave Act. This is an extension of that. This law was signed by President Trump March 18th and was initially going to take effect April 2nd, which was 15 days later, but they've changed that. It will be effective 4/1.
Yeah, Dave, that's a logical date too, in that would be the first day of the second quarter for employment-related tax reporting.
Well, that makes sense. I thought when I first read it, it might have been an April Fool's joke, but apparently not. What is this? What are these acts doing? Well, basically, they're trying to provide payroll tax credits to employers who pay qualified sick leave wages to their employees. Now, we're going to go over what qualifies, who qualifies, how to calculate, but this law is really meant to help the employees that can't work or aren't working because of health or some other reasons, or because the businesses were non-essential here in New York and were requested to close. It is a good thing, though, when you think about it from a couple of standpoints. One being, it helps employers retain good employees. So with that, let's start talking about this new law. Participation requirements. Okay, this is not going to apply to employers with more than 500 employees. Okay, I got a typo there. I apologize for that. Well, I don't. I got it backward in the sense that if you're under 500, this does apply to you. And they've even included a small business exception that if you've got less than 50 employees, you can be exempted. And there are some. It's more of a facts and circumstances, David.
Yeah, David. That would be if the implementation of this act would jeopardize the viability of your company being a going concern. In addition to that, as of right now, the Department of Labor doesn't want any paperwork or applications submitted at this time. The employers will need to keep documentation as to whether the implementation of the act would jeopardize the viability of their company as a going concern. Now, Dave, you and I have talked about this quite a bit over the last few days. Here in New York State, as many of you probably know, Governor Cuomo has required non-essential businesses, quote unquote, to be required to close down. It's our opinion that in itself would provide a very excellent, at least initial fact pattern to qualify for this exemption.
Yeah, and it kind of makes sense too. I mean, if you're under 50 employees, you just might not have the wherewithal to follow through and follow these rules. So I think it's a good exception. The other thing, let's talk about qualified sick leave wages and the credit provisions. So these wages that are going to get paid, if the criteria is met, are not subject to the FICA piece, the 6.2%. They are subject to Medicare, though, the 1.45%. The nice thing here is what you're supposed to get, you're going to get a credit for these wages, not the taxes, but the wages of 100%. Okay? Well, what if you've got a situation where, when you do your 941 calculation and you don't have enough being paid in to take 100% credit? Well, you will get a refund. So how do I get that refund? Essentially, when you file that 941, you're going to show that I've got this big credit and I've only got this much I'm paying in and I'm due a refund. And on the filing of the 941 is presumably triggering the refund.
That's correct, Dave. It's also my understanding with regard to these qualified sick leave wages that they don't currently have a withholding provision for income taxes, but the employees can elect to have federal and state income taxes withheld from those. We're also going to be going through some examples of very simplified examples of how the credit will work, on a 941 filing later.
Right, good. Well, and if you don't do withholdings, I mean, these employees are still going to be taxable. They're still going to be taxed on wages.
Yeah.
The wages, they'd be out of the frying pan into the fire if they don't withhold now.
Yeah, I guess the idea of not having the requirement to have income tax withheld is that these employees may have significantly lower incomes in 2020 because they are subject to certain, these sick pays are subject to certain limits. So, maybe having that income tax withholding money in the employee's hands currently, would be a better benefit with no tax consequences at the end of the year.
Well, that's a good thought. But as employers, make sure you get the required paperwork to change those withholdings from the employee. Okay. So both credits are increased for what's called qualified employer portion of plan expense, health plan expenses. So again, a little bit of an extra benefit for the employer here.
Yeah, nice little added benefit. We're not sure right now how that calculation will go. As you'll see on the next coming slides, the Emergency Paid Sick Leave Act goes for 80 hours or 10 days. So, does that represent a half a month? So if you pay someone's health insurance, say it's $300, the employer portion, do you get an add-on of $150? We just don't know that yet, whether it's going to be pro rata or there'll be some other calculation.
I would assume that's something they're going to provide us the detail on in the regulation.
That's correct. We're hoping.
So as we move on, we're going to jump right into some of the nitty-gritty here with the Emergency Paid Sick Leave Act. So I'm going to turn the mic over to Dave.
Thanks, Dave. We talked about the enactment date being on 4/1 next week. It's important to note that both of these provisions are temporary and are scheduled to sunset on 12/31/20. So they will be running for the next 3 calendar quarters. First up, we're going to talk about the the Emergency Paid Sick Leave Act. This act, it has to be provided to all employees immediately. So on 4/1, all of your existing employees will be eligible for the Emergency Paid Sick Leave Act. there is no minimum employment period, which we'll see on the Expansion Act that there is a minimum employment period. So I would guess if an employee had started with you right before this crisis happened, they would be eligible to collect on the Emergency Paid Sick Leave Act. You see, we've got them broken down into six different components, 6 different scenarios. The first 3 scenarios, your employee needs to be sick, and the sick employees qualify for an increased per day benefit of a maximum of $511. You'll be paying them, they qualify for 100% of their regular pay. So let's just say, for example, an employee was scheduled to make $400 per day. They would be capped at the $400. If you had an employee that made $750 a day, they would be paid $511 a day. Let's take a look at these three components. As sad as they are, number one, your employee is subject to a quarantine or an isolation order related to COVID-19.
That's one, Dave, that you and I, when we first saw this, I remember our reaction. Well, New York's quarantined, and turns out, long story short, New York State is not. In talking with some of the attorneys, were a great help. They explained the detail here, and that the quarantine and isolation orders, there are none issued in New York, but they are issued to particular employees. So there's not a blanket order out there, is what they told us. So that makes a major difference here in how this is applied.
That's correct. It's important to note these need to be made pursuant to a federal or state or local order. So the mere fact that your state may say that they want you to social distance, they want you to stay at home, that is not an order of isolation. We're still allowed to go outside. I just got an email from the golf course that I play at that golf course is open. We're still allowed to do those types of things. We are not being ordered to stay inside. Mm-hmm. A local example of being ordered to stay inside, here in Onondaga County, we have a little north of 400 cases of people who are either infected or who have come in contact with those infected people. Those people are under a local order of quarantine. Those employees would qualify under this act.
Good. Okay.
Number 2 and 3, a little bit less definitive. If your healthcare provider has ordered you or recommended to you that you self-quarantine, that would qualify. Or if the employee is experiencing symptoms and is actively seeking a diagnosis, that would also qualify. We obviously need to wait for the regulations to come out to determine what sort of paperwork is going to be required to back those types of scenarios up. Right. But they are there. Again, the 1, 2, and 3 are eligible for the 100% of regular pay, capped at $511 a day.
Nice.
Let's take a look at scenarios 4, 5, and 6, which are less of a benefit to the employee, but are still, there as an added benefit. Here, we're calculating at a rate of 2/3 of an employee's regular rate of pay to be capped at $200 a day. In aggregate, the most that you can pay the employee over the 80 hours would be $2,000 in that scenario. Who do these apply to? Well, if your employee is caring for an individual that qualifies under 1, 2, and 3, those people, that employee would qualify under this $200 or 2/3 regular rate of pay provision. Number 5, as we're going to find out as we go through our presentation, is really the one that provides the major benefit. And this is if your employee can't work because they need to stay home to take care of a child under the age of 18 due to their school or place of care being closed, or in the case of child care, the provider is unavailable due to a COVID-19 reason.
So here in Onondaga County in New York, that's really a lot of people.
It's a lot of people who may be home caring for their kids, and as we'll find out, there's an added benefit under the Expansion Act, and that's what I'm going to call it because otherwise it's a mouthful, that they'll have an additional 10-week benefit under if they are qualifying under scenario number 5. Number 6 is something strange and unexplained. It's an enigma. This is a situation where the employee is experiencing other substantially similar conditions as specified by the Secretary of Health and Human Services in consultation with the Secretaries of Labor and Treasury. Well, that's a mouthful. I guess Dave and I have been tossing this back and forth. The attorneys that we consulted with really had no guidance whatsoever. They're waiting for regulations on number 6. We've talked about it. Since it's in the hands initially of the Secretary of Health and Human Services, it kind of makes sense that it's going to be health related, but stay tuned.
Right. So, Dave, before we move on, I want to go through a couple of questions here that we received. Will the slides be sent to us after the presentation? After the presentation, the slides will be available on our website, Bowers and Company. And one other quick one here. Any word on how to request small business exception? That was something we talked about on the very first in the general information section.
Yep. And and as I mentioned then, the Department of Labor right now does not want any applications, does not want any paperwork sent to them. The regulations are due out sometime in April. So I think we'll be waiting for those to come out to provide us with guidance as to whether there will be some sort of an application or an application for exemption, or if it will be incumbent upon the employer to just maintain that internally.
Okay, great. All right, let's continue on. And again, we'll have time at the end for some additional questions.
Next, I thought I'd just give you guys, a very simplified couple of examples on the Emergency Paid Sick Leave Act and how they would flow through to the reporting on Form 941. For you in the audience who aren't familiar with Form 941, that is a quarterly form that's filed by all employers to report the wages and to compute the FICA and Medicare taxes that may be due, along with the withholdings that have been withheld from the employees' pay that quarter. So here in scenario on the left-hand side, we're dealing with scenarios 1 through 3 that we talked about on the previous slide. Ayoub Herring Inc. Very prominent company here locally. As we mentioned, in scenarios 1 through 3, the employee is eligible for 100% of their pay for 80 hours with a $511 maximum per day. So I thought I'd just show you the calculation really quickly. We have 2 employees, A and B, who are out sick. They qualify for scenarios 1 through 3. As you can see, employee A, his normal rate of pay for that for those 80 hours would be $6,000. Employee B would be $4,000. Since employee A is greater than the $511 per day, he's going to be limited to $511. As you multiply it out, it would be $5,110. Employee B under the $511 per day, with it being $4,000, so he's limited. Employee B is limited to $4,000. We also have employee C who's not sick and still working. So as we mentioned previously, only the wages that are part of the Employee Emergency Paid Sick Leave Act are not subject to FICA, the 6.2%. Only the $4,500 would be. All wages are subject to Medicare, so the entire $13,610 that was paid for the quarter is subject to the Medicare tax. You can see the math going down. We've computed the total 941 liability in this instance to be $2,313. We have $9,110 of qualifying sick leave wages paid that quarter. that would go as a credit against that tax, so we would be due a refund of $67.97.
So let me stop you there for a minute, Dave. So as you can see, we're looking, in this case, Ayoub Herring Inc. is looking for a credit of $6,797. So if I'm using a payroll service, okay, I mean, I think at this point, one of the questions was, you know, what do I do if I'm using software or I'm using a payroll service? You know, I'm going to be very specific with the payroll service as to what's going on, what employee is what they're subject to, okay, so that I make sure that they calculate it correctly. I can't, you know, I would not simply call them and say, yeah, Dave H is going to be emergency sick pay. Please adjust. There's a lot of dollars at stake here, potentially. I would be specific up front. When you get the report, take your time, look through it. If it doesn't look right, or if you want someone else to look at it, you know, send it over. We'll take a look at it and make sure it's right before it gets processed and filed.
It's an excellent point that I didn't even think about, Dave, is that a lot of companies do use external payroll preparation services, and you know, it's going to be definitely a different dynamic in how you are calling in these payrolls, and like you said, some due care should be
absolutely
done when they go to swipe your account for the total amount of the payroll and taxes.
Yes, yes.
On the right-hand side of the page, we've got an example of scenarios 4 through 6 where you're caring for a person in 1 through 3, which would be scenario 4, where you're caring for your child due to a school or child care closure, number 5, and of course number 6, which we really don't know what goes in that bucket yet. Again, we've got 80 hours paid for the quarter. At 2/3 of A's normal rate, because remember, our first calculation is 2/3 of the regular rate of pay. Employee A exceeds the maximum of $200 a day, so he or she would be limited to $2,000 per day. Employee B, however, also at $50 an hour, 2/3 of that would end up calculating out to be $26.67, again greater than the $2,000 maximum for those hours. So again, limited. And you can see how the math works down on Form 941, very similar to the previous example, except that our qualifying sick leave wages are only $4,000 under this provision, and we're eligible for a credit of $23.46.
Nice. So, Dave, before we move on to the next section, let me address a question that's come through a couple of times, and it relates to the New York State law with regards to emergency paid leave. That's not something we're going to talk about today, only because there has not been a lot on it, and it didn't seem that we could do a very good job with that until we get some additional information from New York State. As soon as we have that, we will incorporate it into this webinar, because I believe we're going to be doing this again down the road. I would say if not next week, probably the week after. So for that question regarding New York State, we don't have anything for you right now, but we're working to bring it to you.
Okay. Now we're going to move on to the Expansion Act, which again just expands on the existing Family Medical Leave Act. And this really only pertains in our 6 scenarios to scenario number 5, where you have an employee who is home taking care of a child under 18 due to closures.
So when you say it only applies to scenario number 5, in the sense that where I think you're going to talk about this is where we may be able to get something under both sets of rules.
That's correct.
Okay.
That's correct.
Okay.
Here we have an employment requirement that they have to be employed for 30 days. So anyone who just recently started with you would not be eligible for this Expansion Act provision. We've mentioned a number of times that it pertains to caring for a child under 18. it goes for a maximum of 10 weeks. Our current understanding that this is in addition to sick leave already taken. So if you have an employee who maybe was out in the first quarter of this year for surgery for 5 weeks and has used those 5 weeks up, it's our understanding that this will be an add-on to that. So they would have an additional.
This is one of those things we discussed to some degree with the attorneys.
That's correct.
Again, people who, this is their specialty area, human resources, and they really didn't have an answer to that. They had their opinions.
Right.
Again, hopefully will be covered in the regulations.
As it was with the Emergency Paid Sick Leave Act, this provision, you first calculate 2/3 of an employee's regular rate of pay, and our maximum here is going to again be $200 per day. The credit mirrors that required paid leave calculation, and you have an aggregate per employee of $10,000. So that would be 10 weeks times 200. So now the first, as I mentioned earlier, this provision has the first 10 days may consist of unpaid leave. We've talked this over, and it's our opinion that the employee would first use the Emergency Paid Sick Leave Act during that time, and then would move over to the Expansion Act afterwards.
Well, it kind of makes sense because there's no waiting period under the Emergency Sick Pay Act that if you had to jump out and you had to take care of a child under 18, you're going to get paid from day one.
That's correct, Dave. The interesting thing is that we're going to need to wait for the regulations to determine the interplay between the two acts. For example, does the use of the 10 days of the EPSLA eliminate the 10 days of unpaid requirement, and does the employee get 10 days paid in the EPSLA? We just don't know that yet. And once they drop off of the EPSLA, do they then have to have a 10-day unpaid period, or have they already fulfilled that requirement?
Right. A couple of questions there. And when we say unpaid by the employer, but what if I've got accrued sick pay, I got accrued vacation time, I can use it for those 10 days.
You absolutely can use that for those unpaid days. That's correct, to bridge the gap.
All right. Great.
And the next slide, again, just a very simple example of, school being closed for 10 weeks. We're under scenario 5. We're calculating 2/3 initially we're calculating 2/3 of a person's regular rate of pay. Employee A, if you do the calculation out, they would be at $1,867 as opposed to $2,800. That's higher than the $1,000 maximum, so they're limited to the $1,000 maximum. Employee B, however, when you calculate 2/3 of their regular rate of pay, would be at $667 as opposed to $1,000. So they would be limited to 2/3 of their regular rate of pay. You can see as the math comes down, the 941 calculation being very, very similar to the previous calculations, except for the Expansion Act wages eligible for the credit are $16,667. So in this instance, we have a refundable credit of $13,379. Quite a benefit to the employee for sure, but at least the employer is getting a subsidy back for providing that benefit to the employee.
Okay. We're getting a lot of questions, and I'm trying to see which ones we can go through and pick out here. A couple of easy ones here just to clarify some things. Question is, what is assumed FWT in the examples? That's assumed federal withholding tax.
Assumed federal withholding. We just did it at 10%.
Right. Another question is, can tax deposits be short paid before 941 filing is done? If I'm reading that correctly,
in anticipation of the credit?
anticipation of the credit?
I would think, yeah.
That's a great question because you don't really know if you're going to have enough at the end of the quarter to cover everything you're due on that credit. So can I short pay as I make those deposits? Great question. I think, again, very procedural, very detailed. I think the regulations are going to hit that 100% when they come out. I really do. So moving into the latter half of this presentation, let's talk a little bit about income tax treatment. Okay, I mean, we are accountants, we are tax people. We always like to talk about taxes. So first one, no double benefit. So essentially what we're saying here is if you pay wages under these provisions, you receive credits for those wages, you cannot take the deduction for the wages paid and the credit. Essentially, the two are going to offset. So if you take the deduction for the wages, you put that in your P&L, you're also going to put into your P&L the income that you received for the credit. That credit would be income. The two would offset, and there's no double dip.
Well, you may have a partial offset because some of that credit may not come back, correct? It may not be cover 100% of the wages.
You're absolutely correct.
So,
right.
But yes.
The idea being, you can't have your cake and eat it too.
That's correct.
Okay. Second item, it can't be combined with other payroll tax credits. In other words, the tax law currently provides for tax credits for certain types of employees or certain functions. So if, a couple here, the small business research, the R&D tax credit, startup businesses can take that credit and apply it against their payroll taxes. So if you're doing that, you can also take these payroll tax credits.
Right.
Okay. So again, just a little bit of clarification on that. Payroll deduction allowed for New York State income tax since no credit is allowed. Well, we're going to kind of punt on that for a couple of reasons. One, as we said before, there's a New York State program that's out there that we're not talking about today that's going to provide some credit. We don't know exactly what it's going to be. So what we're driving at here on this question was, if for federal purposes, we're taking a credit instead of a deduction, okay, and we start our New York State income tax with our federal taxable income. Our federal taxable income has no deduction in it, okay? So would we be allowed to take that deduction in New York State? Now, that's a little confusing, but the answer is, in a lot of cases you can, in some you can't. Again, I think New York State will probably provide specific guidance on that particular issue. But again, we put it in here.
As food for thought, really.
It's food for thought because it will be an issue when you do file your income tax return. Question and answers. So what we've got here is we just wanted to go through a couple of questions that Dave and I kind of threw out at each other that we thought would come through as part of this presentation. So in the first situation, is it possible for an employee to collect basically under both acts?
Yeah, and as we talked about in scenario number 5, where you're caring for a child, you initially can get the emergency paid sick leave for 80 hours, and then the Expansion Act provides an additional 10 weeks in order to provide that care. So the answer to that for scenario number 5 is yes.
Okay. Can you apply the act before the start date? And the answer to that is no. And again, from our conversations and consultation with the attorneys, again, not being attorneys, we can't really give legal advice, but what they're telling us is they're having many, many conversations with their clients because prior to the start date, if their business is closed down, even if it's not closed down, they're asking the question, do I really want to pay these? Or maybe if I am closed down, maybe I should lay everybody off. I mean, financially, can I do this? What's going to happen? So this is, the answer to the question is no. And the reason we bring it out there is because today is March 27th. April 1st is Tuesday. So there is a period of time that if not only these credits, but that if you may be wanting to talk over with your attorney some of the legal ramifications of what's happening and what could happen in your business with your employees, with your business in total, outside the numbers. Right. We address the next question, interaction with the New York sick day law. Again, sorry, we just don't have the details there yet. And the last question we throw out there is what to do after the period for credit runs out. Well, I think
that's a great segue into possibly our next webinar.
I think that's a great segue. In fact, I brought a few tidbits with me today about our next webinar because I think as we sit here and go through this, the House is trying to vote on whether or not the stimulus, the $2.2 trillion package that the Senate passed, that they will pass and then the President will sign into law. And in there are significant items that businesses are going to be able to take advantage of. So before we end this webinar, let me give you a few of those important points. The name of the act is going to be the Coronavirus Aid, Relief, and Economic Security Act. Some people are shying away from calling it stimulus, but I don't know what else you call $2.2 trillion flowing into the economy. Some of the really good provisions that are in this new law to be employee retention credits. Again, kind of to some degree supplementing and enhancing what we've talked about today, providing payroll tax credits to employers to allow them to continue to pay and keep people, even though their businesses may be shuttered or significantly reduced. Net operating loss carrybacks. This is something that was actually eliminated in our prior tax law, that we could no longer carry back a loss. So not only did they bring the ability to carry a loss back, they've said, and this is what the law contains, if you had a loss in 2018, 2019, or 2020, you could take that loss and carry it back 5 years. Now think about that for a minute. 2018 is a year and a half ago. So what they're telling you is, if you had a loss, and let's say you're not using it in 19, or maybe you wouldn't use it all, or maybe you don't want to use it in 19, you can carry that back to 2013 and get a refund.
Now, I'm going back through my memory banks, Dave. That 5-year carryback period goes way back to the old net operating loss rules. Right,
because they trimmed it to 3 and then the 1, and now we're back at 5. Again, it's only for a short period, but again, I think will be something we'll talk about in depth at our next webinar. 15-year recovery property. So everybody, and if you've been at any of the webinars that I've been involved in before, we love depreciation. It's a great thing. And this 15-year recovery period for qualified improvement property, this is the depreciation issue. In our prior tax laws that were passed, there was a technical snafu, and what should have been 15-year property, so in other words, instead of depreciating something over 27 and a half years for residential real estate or 39 years for commercial property, you could take over 15 years, and that was a good thing, and it makes a lot of sense. Well, the technical snafu did not allow us to do that, one, and so it increased our depreciable life, and it took us out of bonus depreciation eligibility. So by putting this back in, we can call that property 15-year property, and now it's subject to bonus depreciation. And we know, okay, bonus depreciation is 100% at the federal level. So here again, what they're trying to do is put money into people's pockets, because this will be retroactive to 2018. So if you filed your 18 return and you had, let's say you had a building you did a cost segregation study, and instead of putting the property on to 15 years, we had to leave it on 39. Well, some of the people we work with on cost segs have that information in that cost seg study, and we're going to be able to go back now if necessary, amend that 18 return, take bonus depreciation on that 15-year property, and who knows? We might have a loss. So now we can use our other net operating loss provision here. How good is that?
Speaking of net operating loss provision, Dave, something else just popped into my head regarding that. The new tax act that came into effect during the Trump administration significantly lowered the tax rates that corporations pay and in general that individuals pay.
Excellent.
If we are going to take these NOL carrybacks back 5 years, there's a good chance that we're going to be getting back tax money that was paid at much higher rates than they are being paid at.
Excellent point. Excellent point. So don't worry. The next webinar will explain these provisions in much more detail. It's already in the works, so stay tuned for that. Right now, let's try and take a couple of more questions. Here's one. We have most administrative folks working from home at full pay. I'm sure that they're putting in the same number of hours. Any relief available here? Not sure what relief you're looking for, but none that I know of.
No, I mean the person is working, getting paid. They aren't out sick. They aren't. Yeah. So
they may, in some cases, they may be more efficient at home. Who knows?
I know here at our office we're going to be finding that out soon.
Yeah. Okay. I'm not sure. Here's a question about what if our employees are collecting unemployment? I'm not sure what they're driving at with that one, so I can't.
Well, I think if your employees are collecting unemployment, they're no longer employees anymore.
Okay.
So they would not be subject to either of these two acts.
That was from Dave's legal degree that he doesn't have. So there's a good one to check.
You might want to check with your legal counsel.
Right. This is excellent. If an employee is high risk and simply is concerned about coming to work, any relief? I think if you go back to the PowerPoint and you look at what they have to do, I think unless they're sick, no. And if they want to know if they're sick, they've really got to number 3 under the Emergency Paid Sick Leave Act, they've got to seek a diagnosis.
Yep.
And hopefully they're not, but if they think they are, obviously go get that. That's way more important than anything we've talked about here today. But that would allow the sick pay to kick in. So I guess with that, I'm going to say on behalf of my partner Dave, our marketing department here at Bowers & Company, and everyone else who made this webinar possible, I want to say thank you. Stay healthy out there, and we'll see you at our next webinar real soon.
Yeah, I echo Dave's comments. Stay healthy, stay safe, and take care of each other.